Yeah.
Lindsay Clancy did the unthinkable to her own children, 3 of them. At first blush, this case looks open and shut. However, it's not always what it seems. Did her medical providers put her in a state where she does not have any criminal responsibility? We're digging in. It's day 4. They're picking the jury. Let's see what's going on. Good morning, actually good afternoon. Welcome to Defense Diaries. I'm your host, Bob Mata, and as always, I am joined by my beautiful and brilliant co-host, still in a foreign land there in her temporary setup. What's up, girl?
Hey, babe. Hey, all.
So, day 4 of jury selection in the Lindsay Clancy case. Today is July 23rd. It's a Thursday. And today we're supposed to get some motion work happening. I think they're on their lunch break now. It sounds like, based on the phone call that you made to the clerk's office, they're all on their lunch break, the whole building. So when they get back, from what we understand, they will be conducting some motion hearings. And what I thought we could do in the interim, I know that there was a motion that was filed by Patrick Clancy, and it was relating to photographs of the children. He was filing as the advocate for the children and the victim's advocate, and he was of the mindset he wants to limit definitely the crime scene photos and basically keep it to, some photos of the 3 kids when they were alive. I haven't seen the actual motion. I'm anticipating that's going to be one of the ones that's argued. So,
well, here's what we do know. Okay. And this is what's disgusting about it. So the Boston Globe, all right, others' response to Boston Globe media partners' request by father of child victims to restrict display of access to certain evidence and trial exhibits. If I'm not reading that right, it seems like they're trying to, like the media is trying to fight it. Like they've got some say in this. Is that what? Maybe that's not what this means.
Well, now that you say that, somewhere I ran into it. I don't know if it was Dee Dee. Somebody posted. I thought it was Tracy had sent me the motion, and I read it, but I can't find where I read it. So, but now that you say that, I remember that one of the requests is that they impound whatever exhibits they put in relating to the children to bar the media from being able to put it out into the public sphere.
Absolutely think that should and will happen for sure. Is that all the father's asking, or he's asking to limit it in the courtroom somehow?
I thought it was both, but I could be wrong.
I'm not sure he has standing for in the trial, but
I don't think he does.
As we all know, this is one of those cases that they don't need unless there's something about the manner, the manner in which the material was applied to the children. We'll just say that the state proves that she was in her right mind at the time. Like, I don't see how it could. But as we all know, in this case, the defendant, Lindsay Clancy, is not denying that she committed the acts. This is all about whether she is legally, criminally responsible, aka temporarily insane, whatever the case may be. Whether she lacked the intent element, the knowing element, or the ability to control herself is really what they're relying on there. So the pictures of the children, they don't need to be in front of this jury. Right. They don't need to be there at all. There is one reason and one reason only. And Bob, let's just throw it to the chat because we all know they know. We all know what it is. Why the prosecution wants to put on details about the crimes as far as graphic photographs
of the children
of the
specifically.
children.
All right. Answer in chat. We know that you'll get it right, as Allie said. All right. So one of the things I thought we'd do while we're waiting for folks to answer, I'm going to pull up our Twitter, my Twitter account, my X account. Kind of look through and see what some of the if you're not paying attention to any of the in-court reporting, they came into today with 17 jurors that had been seated. Something happened with 2 of the jurors, one female, one male. I think the female was young black female juror, and then the older was
Gabe, you've got documents sent to you. Kyle.
I did. All right, I'll check them in a minute. Thanks, Kyle. But what happened is something happened. They went up to the bench, and both of those jurors who were seated were excused. So the number dropped from 17 out of the 18 that are required by the judge to sit on this trial, went back down to 15. Let me see what we've got here in the last. All right, so Nate says 28 minutes ago, juror 381, white female in her 60s, is assigned to seat 13.
And we know what we all said about older women not being the target.
Right.
But you never know.
You can't possibly know.
You gotta have the diversity, which is why we have 12, not 6, not 8.
Yeah, you can guess, but unless you're a mind reader. And then Christina at 27 minutes ago said that lunch break until 2 p.m., which is when we're supposed to go back and have the hearings. And then 2 additional jurors have been seated. So the total is back up to 17. 1 more needed. She had reported impanelment continues at 2. I'm getting some conflicting reports there. Tracy had sent me, let me see whose account that was. It was Kathy. So let me go into Kathy's and see what she said. So that was 4 hours ago. Okay, the judge indicated the jury selection will continue after lunch. We're there ready with cameras whenever a jury is seated and the motion hearing begins, okay?
Right, so it's like you just said, the one you just passed, Tracy said in text, they have 17 again. So if you go right up, that's where she said 17. Kathy, you just passed it.
No, that's not the one I'm looking for. The one I'm looking for is much more upsetting to me. She sent, I don't know.
Well, I think I'm looking at it. The one, if Tracy sent it, why don't you read it from there?
Okay. So this came from Kathy Russin as well. And this was an hour ago. Well, why don't you just let me get to it?
I'm reading it. Read it.
Okay, so this is it. All right, so new info on opening statements per defense. It's unlikely the jury will be seated today at 2 p.m. as the motion hearing, including the motion from Patrick Clancy, lunch from 1 to 2. If jury selection continues into tomorrow, opening statements would be Monday. So obviously we don't like that. Considering we'll be on a plane Monday morning. They have to do everything that they can so that we can cover the openings tomorrow.
Right. So Bob and I have decided, although we trust our chat implicitly, that this is just like too sensitive of a subject for us not to be monitoring. So we're going to do 2 things. One, give you a safe place to watch even when we're not on, that you have people in chat, and you're in a chat that hopefully, that is going to be empathetic to both sides. But Bob and I are going to find time to come on during our during our vacation here. We'll take turns, and it will not be all the time. Right. It will not be while there's an event that takes us outside of the Airbnb.
Yeah. I'll be bringing the Starlink.
We just worry if we, just put y'all into it because I was like, well, we could get 2 people, so there's 2, like, it's more even-sided in case somebody's taking one position too strong, and it's just it's too emotion. So,
It's an
yeah,
emotion.
thanks, Mav. Mav's like, well, I'm gonna stir up shit while you're
Yeah,
gone
I
anyway.
know. I
So,
stuck it on the screen. I
oh,
saw.
oh, I was trying to get to Kyle's
Oh,
X.
let me see what Kyle sent. All right. So that what I just read was an hour ago, and it seems like the most recent update sounds like regardless of what time. Oh, that's still 4 hours ago. Where was the recent one that I just read from her? Oh wait, I got to keep going up.
I can
So
read
it sounds like it had just, babe, just have a bit
Sorry.
of patience. I'm just scrolling up to the top. So more recently, we got in the fact that the judge indicated the jury selection will continue. So the more recent update is when they come back. So we might be delayed on the motion hearings. They're trying to get this jury picked. They're trying to get the jury picked. And obviously I've got Court TV pulled up when and if they're able to get that 18th juror, which I'm rooting for, obviously, then they'll switch over to the motion hearing, which they will be broadcasting or live streaming for us, and then we'll kick it over to that. So that's good. That's good. Like, my preference actually is that they keep plugging away. Like, why stop when you only need one juror? Just get them impaneled, get them sworn in, do the motions so that we can have openings tomorrow. And frankly, what is your position on having openings right before a weekend in a case like this?
I guess as long as it's, I mean, I hear what you're saying, but I also wouldn't want to just eat a day if I'm the judge just because. I mean, as long as both sides get their openings in, maybe it's better because they're not slammed right away with the first emotional, we hear it's going to be the father. So it's going to try to be emotional, but it also have to have some benefit for Lindsay since he's on her side. But I think because usually right after openings, you're slammed with defense witness, defense witness, defense witness, this might actually be better.
Yeah. I mean, it's that concept as to whether or not, and it depends. Every attorney has a different opinion on it. Some people do form their opinion based on opening statements, which is crazy. It's crazy, but people do it. We're human beings, so at the end of the day, I think selfishly, I want them to go on tomorrow. I don't know if it's in the best interest of Lindsay, though, just because it depends. Like you said, if it's openings and they go into Patrick, if he's the first witness they call, which I don't know if it'll be first responders or if it'd be Patrick. If you're the prosecuting attorneys, you're knowing that you're going into a weekend and you're going to want them to be sitting with some heavy duty emotional testimony going into the weekend because you want them feeling a certain way.
Right.
So is that what Kyle sent?
I just took it right off his X because I was taking time for you to find the email. So this is request by father of child victims to restrict display of and access to certain evidence and exhibits at trial to jury and necessary parties. So yes, he's just saying we don't need this out to the world. And I can't imagine there's anyone who in good conscience would say that that's not the way it should be, that this should not be. I don't want to see it. I don't think anyone else should see it. I don't even think the jurors should see it. But so now comes Patrick Clancy, the father of the 3 child victims and the personal representative of their estates, through his counsel and pursuant to Rule 258B, the Massachusetts Victims' Bill of Rights, and he cites a case. And the fundamental privacy interests of Mr. Clancy and his family respectfully request that this honorable court restrict the display of access to certain potential items of evidence and exhibits at trial to the court, the session clerk, the prosecution team, the defense trial team, the testifying witnesses, the court reporter, and the jury. Now, I'm not sure why he even should have had to file this motion. I would have thought that the judge would already have had a rule like this in place. Isn't this when we were watching some pretrial stuff that they were no, I'm mixing my cases up. All right. So moving on to the body. In particular, Mr. Clancy respectfully requests the court restrict the courtroom display and public access to the audio recordings of the initial 911 call made by Mr. Clancy. Well, I don't like that. So I'm against 1. 2, any photographs of the 3 child victims, including pre-incident photographs, crime scene photographs, and autopsy photographs. I mean, obviously, crime scene and autopsy photographs. But I'm fine if he doesn't want pre-incident photographs of his children displayed to the world, then they shouldn't be displayed to the world. I mean, it doesn't hurt the case, and it's not like it's Richard Allen and they're trying to like conceal the whole crime scene.
Right.
You know?
Right.
I mean, well, now I've got to switch. Okay. Oh, that's the same page.
Well, if you would have had just a little bit of patience. He sent it to me, and I've got the whole document. He sent it to me in X, so
I sent it to you too, but I think he emailed it to you as well. Argument. Mr. Clancy respectfully states that absent an appropriate order by the court, various recordings and images of such evidence and exhibits will be displayed, published, and disseminated by the media, on television, newspapers. The potentially harmful and everlasting emotional impact to Mr. Clancy and his family. I mean, I guess he doesn't want to hear his 911 call over and over and over.
Blow it up a little bit more if you can. Yeah,
you know?
Yeah. Yeah, I mean,
I don't know. It depends what's in the 911 call. I think that we will get the gist of it even without hearing it. So for selfish reasons, I really would only want to hear it if it said more than like something, just like this horrible thing happened to my kids, come right away, which might be it. I honestly couldn't hear it.
I think when the 911 call takes place, that he finds Lindsay first. Like he said, like from what we've read in terms of the complaints on the civil side, it sounds like he's pulling up to the house. He sees that there's like blood on the window on the second floor in what would be their bedroom window. And he gets out of the car. I don't know if he goes into the house first or not, but he ends up discovering Lindsay on the lawn. And then that's when he calls 911. I don't, right. Because like we've seen the things where we're seeing the affidavit for the search warrant. I think when we were going through that one of the first responders is like, they heard Patrick yelling from down in the basement.
Yeah, I think in retrospect, I think it's fair about the 911 call. I do, because if there's this isn't like he's the defendant, so we want to hear his tone. You know what I mean? Like
right.
That's when like the way he's talking and what he's saying is important. This is just honestly, it would probably be heartbreaking for us to even like. Well, we all know it would be heartbreaking for all of us to hear as well. And I can appreciate him not wanting it like plastered all over the internet for, ever and always. You've got like his entire family line. You know what I mean?
Yeah.
Like it's a lot.
Yeah. So, and Schmida here has a pretty good comment. I find there's way more compassion for mental health in chat than there is in the comments under news articles. There's a lot of people who want her guilty. And, that's kind of what we've been talking about for, the recent lives that we've been doing on this case, is that I think, and it was kind of what the heart of my brief cold open was, that at first blush, when people don't realize all the facts with regard to what Lindsay was doing in order to try to get herself right mentally, how many treaters she went to, the amount of SSRIs that they were putting her on, and just meds in general. That's why we can ask is for people to wait, hear the evidence. Because at the end of the day, this trial is going to boil down to one thing. We're all going to have to sit through, the horrors of that day. in terms of the state having to meet that burden beyond a reasonable doubt that she in fact did end the kids' lives. Uh, and so they're going to have to prove that up. We're going to hear that portion as if that's what the trial's about, but it's not, because there's no question that Lindsay did it. The question in this trial, the heart of this trial, is whether or not she lacked criminal responsibility. This is a straight up insanity defense case. So, and it's just a very, very important case. But at first blush, when people hear about, somebody who's done this to their own kids, your initial instinct is bury her under the jail. Like that's the way that 95% of the people are going to feel, unless you've got the people out there like, whoa, wait, we have to, even if they don't know the facts, wait, we have to hear all the evidence. And if they understand what the defense here is, so it's like, it's hard to judge what people know from comments and under news articles and stuff like that. If they're just surface level reading the article and it's talking about the awful shit that happened that day, then it's understandable that people would be like, their initial instinct is like, wow, she's guilty. Like, why are we even having a trial?
So, sorry.
Go ahead. No, I was done.
Okay. So, but I also want to point out, like when she says, like to Shmita's point, which is a good one, like there's a lot more compassion for mental health here in chat. You have to think of it. And I was trying to think of an example that like everybody could agree on. So I've chosen one that I hope everyone can agree on. And if you don't, I don't really need you in our chat. So like if you grew up in a house where it was a KKK house, for example, so something extreme, and all the kids are taught is hate and, whatever they're taught. If that child doesn't get out into the world, and it's like the one reason that I say I still think college is important, not for the degree, but for the opening of minds for people who have just not been exposed to different thinking and different ways of thinking. So if you think of it like that, like this kid grew up in a bubble and almost has no choice but to grow up a racist, right? It's not until he hears views of other people that he can start to like, oh, wait a minute. There's another way to think of this. There's another way to look at it. And all of you in this chat have been exposed to that, not only by us, but by whomever else that you're listening to as well. So you've had some food for thought. It literally is it is what it is, and it helps you to think of things sort of differently and be open to different things. It's not that necessarily has to change your mind, because you could get exposed to that and still say, all right, well, I've kind of thought of this from all angles and this is where I land. But if you don't have anybody bouncing other angles off of you, bouncing other theories off of you, opening your mind to think of things a little bit differently, that's what you're going to get. That's what you're going to get. So I think, and I hope that's why, you find more compassion here in our chat, and hopefully in other chats of other creators as well. I didn't mean to take down, I was going to put this back up. Hold on. I messed up. I don't know how to get back to it here. Oh, here we go. So let's go to page 2. We were on page 2. So, and I'm just going to skim here, so likewise, the respect for the dignity and memory of the 3 child victims that would inherently be occasioned by such dissemination speaks for itself. Conversely, an appropriate limiting order by the court would prejudice neither the Commonwealth in its prosecution of the defendant nor of Miss Clancy. And then it goes on here, indeed, well, let me actually, the court, the testifying witnesses, the trial attorneys, and most importantly, the jurors would not be adversely affected in any way. Indeed, from the jurors' perspective, the items at issue would be viewed and evaluated like every other piece of evidence or exhibit introduced at trial. In truth, the only real consequence of such order would be a humane and noble one that would reflect honorably on the criminal justice system. And he puts what it's out there. The father, whoops, I was going to highlight, but that's not an option here. The father of the 3 deceased child victims, as well as their grandparents, relatives, and all those who knew the children, will be spared the emotional trauma that will be caused by widespread public display and dissemination of graphic and sensational trial exhibits related to the trial. And they cite some cases, as the court's aware. Although the right to access to criminal trials is of constitutional stature, it is not absolute. And I think everyone can agree to that. So they said some things for that. And then the last page, are you watching? I got X up.
Yeah, I've got this
I mean,
on. I'm
YouTube.
trying to figure out. I think that this is old footage. Like right now, Reddington is addressing the court, but I think they're showing clips from decisions that have been made in the past.
I have it live. I think right now they're just talking until the court comes back in. I'm just not listening because I'm listening to this. So just share this live on go to Court TV and put it live at the bottom for yourself, and until they show and mute it until they show the screen, I guess.
I was just seeing if this was anything interesting in terms of other things that were said in court that we didn't cover, because what they're doing, like to kill time, is that they have talking heads on, and then they're showing portions of hearings that took place regarding other issues. Some of them are probably worth listening to.
All right, let me just finish this up then.
Okay.
So they just go on to say that the legislator directs the Just Act to assure the victims of crimes are afforded the rights established in the Bill of Rights. They cite some more authority, and he says he's not seeking to close the courtroom or to prevent the public or the media from hearing testimony at trial. Rather, as set forth above, Mr. Clancy seeks a narrowly circumscribed order limiting the recording, display, and disclosure by the media and any other persons. If disseminated, would only serve to perpetrate the already severe emotional harm to Mr. Clancy and his family. And in a footnote, he says, likewise, for the same reasons, to the extent that the court treats Mr. Clancy's request as a motion to impound certain evidence at trial, Mr. Clancy submits that, quote, good cause exists for the court to restrict public disclosure of the evidence. And he cites the statute for that. And then that's it. I mean, conclusion, what he's asking for: the audio recordings, the 911, the photographs, and any clothing associated with the 3 children. So I think that the court's going to grant that. I don't see why they would not grant it. And then we've got the courtroom screen here. I'm going to share this until you find something else that you want to.
No, I found something else. I've got it queued up. All right.
Oh. And I'm watching the courtroom.
All right. Let me get the audio on. All right. So this, I believe, was some argument regarding an instruction.
Sorry, I'm removing it. Don't worry. I just wanted to put it at the bottom so I could see it.
Oh, yeah.
Sorry.
Oh, yeah.
I'm watching the courtroom.
So this is going to be some argument from Reddington about an instruction that the defense wants read regarding the burden that the state has to prove beyond a reasonable doubt that she did not lack criminal responsibility. So that's what this argument is going to be.
Your Honor, when you give the instructions to the jury on the law after we've picked the jury, and I believe you do it before openings, in light of the fact that it's obvious that lack of criminal responsibility is the central bedrock of the defense in the case, I would ask that the court would, in addition to instructing the jury, as you do in a generic sense, about proof beyond a reasonable doubt, that the court would also instruct the jury that as it relates to the burden of proof, in the unusual situation where you're dealing with lack of criminal responsibility, that it is not the defendant's burden to prove that she is lacking criminal responsibility, but in fact, upon presentation of evidence, it's the government's burden to prove beyond a reasonable doubt that she was not acting as a result of a mental disease or defect. So I'm just asking that you would add that to the generic instructions.
Your Honor, similarly to the argument that the Commonwealth was objecting to the criminal responsibility being mentioned in the statement of facts, we would also object to the preliminary instruction, full instruction about criminal responsibility, because as my sister said, it is the defendant still has to raise it, and they have to raise it not just by saying it in an opening statement, they have to raise it by expert testimony, lay witness testimony, or the actual facts of the case. And so that isn't done until the case is underway, and preliminary instruction it comes well before that.
This is a different scenario.
What if I instructed the jury in a sense, almost like hypothetically, that it's anticipated that the defense of criminal responsibility is going to be raised? If that's raised, this is what the law is.
The law.
Well, I would suggest that we don't want to be caught in a burden shifting situation on a preliminary instruction. So maybe that language is a little bit too close. I think it's either Your Honor gives it as it is in the model in the preliminary as a preliminary instruction, or it's not to be given and just to be addressed at the conclusion of the case.
I think it gives it.
Give it. I understand the Commonwealth's position, but I generally think it's a good, well, I'll just leave it at that. I generally will give that. So I'll take a look at, but I generally give the model language that's suggested.
Thank you,
All right, let's
Judge.
bring in our panel of experts.
So
yeah, let's explain what happens. So typically, when you give your jury instructions, if it's something that requires the defense to raise it, like self-defense, like insanity, something like that, you've got to wait. Like if you think about the Karen Reed trial and you think about, well, are they allowed to put on third-party defendants? And she was like, well, I'm going to let you argue that the officers and the detectives didn't do their job. They didn't do a full investigation, but you're going to have to reach that level before I let you put on strict third-party suspect evidence. So that's typically what happens. Like you've got to put in enough evidence so that the judge knows, all right, this is actually going to be an issue in this trial. I mean, it doesn't matter here because the judge ruled in favor of the defense, but in this situation, there is no question, there is no doubt, there is no like, well, what if they can't, what if they don't put any evidence in? What if they don't ask the right questions? Like that's not happening here. So the pushback from the state, I think, was disingenuous. The judge did the right thing. He's going to inform the jury in the beginning as a preliminary instruction about criminal responsibility in Massachusetts. Now, there's still no one in the courtroom yet, babe. I don't know if there's anything else you want to share. Otherwise, maybe it's a good time to let everyone know about that instruction or what the criminal responsibility statute says.
I'm trying to see, I think there was another little tidbit here regarding it. I think it's for jury views. So let me throw that back up because it sounds like they're going, I thought I read something about them doing 3 jury views. Now, I don't know if that means that they're going to do, I don't know if they're considering that constitutes one, like the lawn, and then they're coming back. It seems like they would do it all on the same day, which I don't really know. Let's hear what the argument is here.
Jurors will see at trial outside the walls of the Plymouth County Courthouse. Now, last month, the Commonwealth of Massachusetts, they asked the court to approve the transport of jurors to 3 different locations.
I was approaching it as most of these types of cases that I do. We usually let the homeowner know when we'll be there. They make sure they're out of the home and it's unlocked, we go in. A case like this where we have 18 jurors, maybe send them in groups of 4 or something along those lines to see whatever myself and defense counsel want them to take note of, and then leave the premises with an instruction to the jurors they're not to open any closets or anything like that or touch any personal items. And I think that's pretty much what's encompassed in the order, if I recall.
Can I ask that the court at least limit the police presence? I mean, I have had it with police officers on motorcycles buzzing back and forth next to the jury bus, and police officers stopping traffic and blue lights behind you, blue lights in front of you. There's no need for that type of a police presence in this case. We're going to take a bus to a house in a residential area in Duxbury, and that's it. I understand that there may be a need to, I guess, I don't know, close down a road or something, but I would ask that we don't have such an overwhelming police presence for obvious reasons.
Come on.
We could go to sidebar. We do have a plan in place, but for security purposes.
Sure, yeah. Is he in sidebar?
Ultimately, the judge approved this motion for a jury view. So the jurors will be taking that trip to 3 different locations. Number 1 will be the Clancy home. And here's a portion of that motion as the prosecution asking for the jury to observe on a view these various locations identified. And they say it's important to understand specific issues to help this jury so that they will have to determine, including things that they will have to determine, rather, including the time and distance between the locations at issue. Let's bring in our panel to see what they think about this case. We have with us Dr. Debbie Goodman, Dr. Priya Banerjee, and David Bruno.
All right. So we'll pull that off. Okay. I mean, my position on the jury views.
So stupid.
You know what, though? I mean, you can make the argument if you're the prosecution that, look, their position is that she wasn't psychotic, that this is a ruse, that, she did things intentionally and that, it was premeditated on her behalf and, that she was trying to get rid of her husband for as long as she could in order to do this horrible thing that happened that day. And, ultimately, this thing's going to boil down to, the state's going to put that case on. That's what their position is. Now, it's going to be entirely up to the defense and truly up to their experts to educate people on the reality of psychosis. And, or if this was, something else or a combination of psychosis and, the toxicity issue. I've been trying to get, he's a psychiatrist that I was telling you did it's like just shy of a 20-minute live, and he was talking about, the level of medications she was being prescribed and the kind of the way it went down. And he was very thorough, and I'm trying to get him on the show. I ended up, I can't find his contact. If anybody knows, I know a bunch of you out there have watched that particular video. If anyone has any way for me to be able to communicate with him other than I posted on one of his X posts that wasn't related to this case, hoping that he'll see it. And then I asked him to DM me because he'd be very instructive. Like he's a guy, it would be like having our own expert on to kind of explain to people from the pharmaceutical side of it, the issues that were presented with how they handled her treatment. And we're talking about the 4 different providers. So yeah, Dr. Joseph, exactly. Thank you, Brooklyn.
And then like Steph Oregon says, my brother is schizophrenic and people in a psychotic episode are scary. And it is always a fight to even get the doctor or the ER to help our family, even though I have guardianship. I mean, we're all hearing stories from so many people about just how horrific, it is. And thank you, Steph, and thank you, Casey. She says, thank you for your thoughtful and respectful approach to this heartbreaking case.
Yeah, of course. So this is something that I was thinking about, and as we've been progressing through our coverage of this case, you know, I read the chat pretty diligently. I definitely read all the replay crew comments that people leave on the videos when they're watching after the fact. And what's pretty evident to me is that there are an awful lot of you folks out there that have this type of experience firsthand in your life, whether it was a family member, whether it was yourself. And I just want to throw it out there as a potential option, maybe on an off day, because a lot of people have been sharing their experiences, and Allie and I would love to be able to give you the opportunity. If you wanted to come, we could do it like where we do the call in. If you wanted to come on the line, I'd like to do what the defense was basically barred from doing, which is to bring on people that have firsthand experience with mental
And you
illness.
don't need to have your cameras on if you don't want. You
Yep.
know, or you
Yep.
could leave it as an audio, and maybe it would help everybody. Because Bob and I were trying to think of a way, like, because we know everybody needs like an extra hug
Yeah.
for this stuff. So I actually had reached out to our friend who's a musician, and he has this song Only Love that he always does like this when he's performing. Like, he starts with asking the crowd, like, do you believe in the power of love? Or do you believe in the power of love and music? And then like gets the crowd like into it. And I was like, oh, I feel like, and that's where Bob and I are going to be, by the way. We've got two friends who have big birthdays. So they're doing this dual party, and it's Tuesday, Wednesday, Thursday in, at an Airbnb in the Catskills. So I was thinking,
Is it
maybe
the Catskills or the Poconos? I thought it was the Poconos.
I don't know. It's out there somewhere. It's either
It's in the
New York,
mountains.
the New York, Pennsylvania border somewhere. We'll figure it out when we get there. But I was like, oh, maybe we could like play that in the beginning. And then Bob's like, oh, then other people will think that we're being heartless. So I'm like, all right, there's no way to know, what's what. So maybe this would be a good way for people to have like a chance, maybe even after each day, something that Bob and I will be able to do. We can find an hour to do us, after the trial day, even if we're not on the full stream during it, where we let this happen and you guys can kind of share your emotions, talk about how you're feeling. I don't know. Let us know.
Yeah. So what I'll do, and what I was intending on doing, I'm going to create a community post over on our community page. And I really want you guys to let me know if there's anybody, and I don't care how many, if there's 50 of you, we'll give you the space, we'll give you the time, because it's important. Like I said, when we were talking about that issue when it was raised in court, whether or not the judge was going to allow the defense to put on people that had similar experiences to Lindsay. The judge ultimately ruled, and I think Allie and I agree that he ruled correctly, that it just creates a little too much of a trials within a trial issue, and there's going to be differences. It could work either way. Some of those witnesses may have worked against the defense ultimately, so in terms of the judge's decision, I agree with them, but that doesn't change the fact that I think that there's nothing more instructive for us, for all of us, in terms of learning, to hear from people that have actually experienced this in their lives and have firsthand knowledge. I mean, to me, there's nothing more invaluable than that. So when I do that, please, you guys go on to the community page and let me know whether or not you're up for that type of thing. If we get enough people that are like, yeah, I'd love to share my story, it's important, then we're going to do it. All right. So yeah, I mean, we support you. That's what I'm saying. Like, I've seen so many comments and they're so thoughtful and heart wrenching, and it's people's lived experiences in terms of dealing with mental health issues with people that they love or with themselves. And I want to hear it. We should all want to hear it. It's important. So, all right. I'm sorry. What were you saying, babe?
Let's see if we could find the, because from the docket, it shows, and I think that we thought maybe they'd talk about it today, but there's a doctor that the prosecution filed a motion to compel him to attend and testify at trial, a Dr. Eaton Negril, which sounds like it's a doctor of that treated Lindsay. And then they filed an affidavit in that. And then the judge found that he was a material and necessary witness. And that was an order yesterday. So I don't know if that, I was trying to look at to see if there was any footage from that.
I didn't see anything. I saw that the order had come down. Tracy sent it to along with the motion. And there was no real indication that if it was like a HIPAA issue in terms of, because apparently this doctor was one of the treating physicians. I think actually this is the doctor who sutured up her wounds on her wrists, in terms of why that doctor was resistant to testifying in court. I don't know if they were relying on patient doctor confidentiality or what the issue was. So they didn't really get into that. So, I mean, I have those motions. Do you want me to pull them up, or do you like, cause I don't know. Let me go back. I'll see if there's any more.
I'm looking too, and I don't see anything of courtroom, of courtroom coverage. I see talking heads, but not.
Yeah.
I'm trying to look. Maybe there's.
I scanned through this entire one. It will probably be more instructive for you to be scanning through a different day. Like
There
I've
were
made
two yesterday, so I did the first one. And now I'm doing a second one.
Okay.
Like I see the courtroom, but I think this is just her talking about what's going on in the courtroom.
And just a bit of a reminder, at 3:15 today, it may end up being 3:20 depending on when Aaron gets home, but Aaron Spencer's attorney, if you guys are familiar with the Aaron Spencer case, he's the hero dad whose case was on the eve of trial, and the judge dismissed the case in its entirety with prejudice. Aaron is the hero father who had ended the life of the man who had been abusing his daughter, had been arrested, had made bail, had a protective order against him in terms of communicating with any kids. This guy violated all of it. He continued his grooming of the daughter while he was out during this 3 months on bond, and ends up getting his hooks into Aaron's daughter again at 12:30 at night. And Aaron and his wife end up finding that their daughter is gone when the dog wakes him up, and Aaron goes out to find his daughter, and he sees them, Michael Fossler, the guy, and his daughter turning back onto the road. A 6-mile high-speed chase ensues, and then at some point during that chase, Aaron was able to successfully complete a pit maneuver to get that vehicle off the road. Fossler jumps out of the truck after Aaron screaming for his daughter to get out. She's not getting out, and Aaron ends up putting 15 rounds in him and kills him, and then calls 911. He's then subsequently charged with second-degree murder. That
First,
case,
he was charged with first-degree murder because they're out of their minds, and still second-degree murder was out of their minds. But as you would expect, the public was outraged, legislature was outraged. I mean, everybody was outraged. So we're going to get into that. The case, as Bob was getting to, was ultimately dismissed on a motion. Technically because of evidence that, of course, they just, evidence disappears. We don't have the body cam footage, and we told everyone to turn off their cameras, and things go missing. So we're going to get into all of that. We are still waiting for we're watching. The courtroom's not back up yet. I did.
So at any rate, let me finish the announcement. So at 3:15, so Aaron Casanelli, Aaron Spencer's attorney, and Michael Lassiter, her other or Aaron's other attorney, are both going to be joining us. I don't know if Michael's going to stay the whole time, but Aaron's going to stay, and it's going to be a fascinating conversation for sure.
I feel bad because it says interview with Aaron Casanelli.
She just asked me today.
Okay.
She's like, "Oh, do you mind if Michael jumps on?" And I'm like, "Of course not." Yeah. So
anyway, I wanted to thank Jen Uwine, 50 Defense Diary memberships. That's
wow.
Especially at this time, because more people that are our members are more, like we just think for us, and I know Bob's said it a billion times, so I'm just like re-saying it, that this is such an important case because it's so horrific that to get people to consider the mitigating factors is so important, because it's a time when people are not going to want to be open to any mitigation. They want to just say, no, that's it. Your kids are gone from this world. You did it. I don't need to hear another word. And the way the law has been treating it, because I'll tell you, in other states, this whole, compulsion, it wouldn't fly. It wouldn't even open the door to them. And that's one of the things I wanted to share. I know we have shared this with you guys in the past, but let me just bring this up. Is it shared, babe?
No,
it's at the bottom.
No.
Okay. I'm not going to read the whole thing. I'm just going to read the important part. So this is about the Commonwealth having to prove beyond a reasonable doubt that the defendant did not suffer from a mental disease or defect at the time of the offense. Then they get into it's not a strict thing on mental defect or disease as to how they prove that. But the second way, okay, for the Commonwealth to prove the defendant was criminally responsible for their conduct is to prove beyond a reasonable doubt that even if the defendant suffered from a mental disease or defect at the time of the alleged offense, the defendant nonetheless retained the substantial capacity to appreciate the wrongfulness of their conduct and to conform their conduct to the requirements of the law. And that's where this case lives or dies. They were very clear. We went over in our primer episode, we went over the civil complaint. They were very clear that she felt that she could not even control her own body. She could not, that the voices were powerful, overwhelming, compelling. She didn't even feel like she was in her own body. It was like she was watching what was happening. So that's where this case lives or dies. So this is the instruction that the judge just said he will read ahead of time. So they say to establish the defendant had the substantial capacity to appreciate the wrongfulness or criminality of their conduct, they must prove the defendant appreciated, that is, the defendant knew and understood in some meaningful way that their conduct was either illegal or wrong, So I don't think there's going to be much pushback on that, but maybe they're going to say she was so psychotic she couldn't even appreciate what illegal or wrong even factored. But I think it's more going to be the second part, to establish the defendant had substantial capacity to conform their conduct to the law's requirements. All
right, hold on, babe. I'm sorry to interrupt you. We're getting some updates here in chat. Final juror has been seated. So 18 have been now seated. It sounds like what's going to happen, so let's keep an eye on it. Patrick Clancy, I saw another one of our beautiful chatters telling us that Patrick Clancy's attorney is in the courtroom. So we'll keep an eye on that. We will switch over to that coverage.
We have the screen up behind us. Yeah.
Yep.
Check it. I've got YouTube up Court TV up for me. Maybe just check a different channel, Bay. So just the last part of that was that they must prove beyond a reasonable doubt that any mental disease or defect that may have existed at the time did not deprive the defendant of their ability to behave as the law requires. That is, to obey the law. I also think, and I'm just not sure how it's going to play out yet, that the medication aspect of this could come into play as far as dealing with involuntary intoxication, in that she was unable to know the effect of the medication she was prescribed. So in that sense, involuntary or voluntarily taking prescribed medications that you don't understand are going to have this effect on you. And we're going to have to keep an eye for how that's going to play out, in this trial as well.
For sure. Most definitely.
You're looking at Boston 10 or something?
Yeah, I think that Court TV is the pool camera.
Okay.
So, I think that they're the ones who, when they go live, it's live. I mean, because my preference would be to have Boston 10 because they don't dip out to talking heads in the middle of.
There we go. Something's happening.
Where'd it go? Where's the picture?
It's there, but it's not there. Like that's what's showing right now. Oh, it's back. Do you see it?
No, we see a gray screen.
Oh, because you removed me? I don't know
No,
how that happened.
I didn't remove you.
Oh, maybe I wasn't. I don't know what happened. Here we go.
All right, there we go.
Yeah, I don't know what happened.
I don't know what happened.
Did you read Not So Zen Jen?
I did not. I haven't
Looky,
read.
happy anniversary. Love my Defense Diary family. Yes, happy 18 months. We appreciate
18
your
months.
continued support. And Genuine, welcome. And I think that's who
Gift of 50,
all those
80
memberships.
memberships. Let's fill that
Wow.
up again. That was amazing.
That's very
It's
generous.
amazing.
New
So
member
generous.
gifting 50 new memberships. Very generous.
Thank you. Thank you.
At for Dread, this was earlier. Hey, Bob and Allie. I've seen that they selected 2 to 3 more jurors. Some got excluded per Christina Rex. I don't know if that's who you were looking at, babe, or which coverage you were looking at.
Yeah. Various people were talking about the 2 to 3 that had been excused, or it was 2 were excused. But
yes.
The new update is we've got 18 seated. So
right.
That's the new update.
So Casey became a new member. Welcome. And I think that we already put up a thoughtful comment from her as well, which was actually this one. Thank you for your thoughtful and respectful approach to this heartbreaking case. Well, welcome. What'd she get, babe?
Oh, family hug. That's what she gets.
Did Jen get
and that's
hers?
for all the new 50 members.
Yes. Yes.
Group family hug.
BB King, we appreciate your name and your we love music here and your comment here. Will you be flying up for trial, please? Bob's been tempted, but I don't know.
I mean, it's a 6 to 8 week trial. There's
maybe you can get up there.
There's a strong possibility that I will end up there, to be honest with you, especially as we get into the defense's case in chief. Like that's because that's where the rubber hits the road, really.
Right.
All right, I'll keep rolling. I don't know what you're looking at. So at Dread, thank you for the 5. No worries. At the end of the day, you have to protect the platform you built on integrity and the principles that you believe in, as to why we're all here. Yeah, I think that was relating back to us talking about leaving the keys of the house to the kids while we were on vacation and being like a little nervous about it. And it's not because we don't trust any of you, because we do. We love you all. It's a volatile trial potentially with strong feelings going both ways. And I don't know if this would be the right trial to kind of just let you guys run wild in here. I don't know. So we'll see. But thank you for that, Ad4. I appreciate you always. Stephanie, thank you for 7 Canadian. Montrealer here. Glad you're covering this. Anxious to see if the court system catches up with real life, as are we. You guys have really hit your stride, by the way. Thank you very much. We appreciate that so very much. And thank you for your generosity as well. Casey 70 threw 10 at us and said, thank you for your thought. Oh, Allie read that one. Thank you for your thoughtful and respectful approach to this heartbreaking case. Thank you once again, Casey. And I think Allie had thrown Steph's comment up as well. My brother is schizophrenic, and people in a psychotic episode is scary. And it's always a fight to even get the doctor and or the ER to help our family, even though I have guardianship. How terrifying and frustrating, I mean, that's the bigger part of this. It's just our country in particular. And I can't speak to the UK and our friends down in, down under in Australia and our friends in Scotland and Ireland who are all part of this community. I can't speak, or even our friends up in Canada. I can't speak to their health systems up there. But I can tell you here in the US, it's a nightmare. It's an absolute nightmare. And when it comes specifically to mental health, I think it's probably the worst of the bunch. It's just, we were talking about it with our now 20-year-old who had her birthday yesterday. It's like the concept of what used to take place back when they used to have these institutions and they didn't know what they were doing, and they were lobotomizing people and shock therapy and just all this kind of like barbaric shit that they were doing, that wasn't really moving the needle in terms of treatment. They ended up closing these facilities down. Like, there's nowhere for people with ongoing mental health problems that need inpatient that they can just walk in and get into. It's like the whole nightmare process. There's so few facilities, and you need the right doctors treating. You can't just go. It's a nightmare scenario. So, that's one of the many reasons this case is so
talking
important.
happened in the background there at the courthouse.
Oh,
I
okay.
heard something.
Hot mic.
I don't know. Let me make sure the sound is up.
And thank you. Make sure you don't have that little X by the speaker. That's my move all the time. Cubicle counselor, 1,000 gems, go trophy. Thank you so very much. And then Genuine, that's worth showing about 5 times, because 50 DD podcast memberships, that's a lot. That's generous. We're so thankful for that. Thank you. She Boogies. All right, here we go. I'll get back to it, Spooks. What did you do? Oh,
Not me.
May I proceed, Your Honor?
Yes, please.
Your Honor, before the court today, we have the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington, and the Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right. All right, so I think we have a motion. And why don't we take up was a request it's entitled, request by the father of the child victims to restrict display of and access to certain evidence and exhibits at trial to the jury and necessary parties. And what I thought I would do is first hear from counsel for the father, then I'll hear from Commonwealth, I'll hear from the defendant. So counsel? Yes.
May I approach you?
Yes, please. Thank you.
Judge,
Please state your name for the record.
good afternoon, Your Honor. If it please the court, Ms. Sprague, Ms. Buckingham, Mr. Reddington, my name is David Meyer, M-E-I-E-R. And I appear to the extent that Your Honor allows me to appear on behalf of a potential witness in the case, the father of the 3 victims in the case, Patrick Clancy. If I could, Judge, could I see the court briefly at sidebar?
Sure, absolutely.
all right. Sidebar. That guy's got a fabulous head of hair. It's so fabulous. I'm curious if it's a rug. No comment from my wife. He's got nothing.
Sorry, I'm busy. Sorry.
Oh, no worries. So this is going to be it. So I think this might be the only motion that we're hearing. And then I don't know if the move is going to be, after the motion's heard, that they're going to bring the jury in, swear him in today. I would assume that they'll swear him in today, but maybe they'll swear him in tomorrow. I don't know if they'll do preliminary instructions today or tomorrow before openings, but I'm hoping we're going to get some kind of information in terms of when openings are going to take place, which I'm assuming we will. So, all right, let me keep rolling while we're waiting for the sidebar to go. I left off with Shaboogies. I just love you both so much. Kind, knowledgeable, hilarious, but the empath is strong in you both. True story, which makes for amazing defense attorneys, clearly. I mean, I don't think you can do the job effectively as a defense attorney if you don't have empathy. It's a completely different job than prosecuting. It just is, because you're dealing with the defendants, you're dealing with the defendants' families. You learn about, the lives that they've led up to the point whenever whatever crime they've been alleged to have committed takes place. And you need that background. And, you know, I mean, part of our job has always been to try to humanize these defendants in these cases, because, you know, prosecutors get a file, they've got a stack of them. You know, they're high felony prosecutors, they don't have quite the caseload that some of the lower felony prosecutors have. But whatever the case may be, there is no small case. There's only small lawyers. Every case for every client is the most important thing going on in that person's life, and that has to be respected and acknowledged. And, you know, we are often spending time trying to humanize our clients to prosecutors who are simply going off a piece of paper. They have no idea who this person is, nor do they seem to care. Additionally, you've got the police reports wherein they're making their judgments based on that and that alone. So, you know, we spend huge amounts of time trying to get through to these people that are prosecuting these cases, and say, look, you know, this is a human being. Like, this kid's 18. This kid was going through that, like, this particular situation. You know, let's have some sympathy. Let's, I'm not asking for a pass here, but let's make the punishment fit the crime and take into consideration mitigating factors of what may have led to that thing happening, as opposed to ruining this kid's life and hanging a felony on him. And, you know, I mean, that changes the arc of somebody's life unbelievably, you know. And it's like, when we start talking about the development of the mind with kids that are young, Allie's adamant about her feelings with respect to trying kids that are 13, 14, 15-year-old as adults, because their minds just haven't formed completely. It's factual. It's not a guess. Like, they're still developing up until their early 20s. You know, I've read literature that it's, you know, into the mid and late 20s, your brain is still developing. Obviously, we're never going to be able to convince anybody that a kid after, you know, the age of 18, I mean, that's been set in stone in this country for so long. You know, they're going to try you as an adult, but, you know, as far as kids that are under the age of 18, it's, you know, it's a different story. And it's one that, you know, and they're all, like, all these different issues are intertwined when it comes to the mind, the human mind, which is so complex, you know. All right, let me keep rolling here. And thank you for that, Shiboogies. We appreciate you. Uncle Alert, Perry 3 with 440 gems. So we figured out that these little comments are actually, like, you guys are seeing them on, we don't see them backstage on StreamYard. All we see is the description of what the emoji is. So the Uncle Alert one is an emoji. And you know, if you don't have kids, like, the unk, you know, the kids are calling old people unks now. You know, I'm like, I guess it's mildly better than grandpa. But I am a grandfather, so, you know, I mean, I'm fun pa, for God's sake. So there's no shame in that game. I love it. I wish we could see our grandchild a lot more. That's a different story for a different day, though. But thank you, Perry. We appreciate you. Tabby with 1,000 gems. Air travel. Thank you so much. We appreciate that. 2 gems from Lily Rose. Thank you. With sparkles. Perry 3 became a new member. Oh, family hug. That's what we give over here to our new family members, because y'all are family for us. There's no question about it. And thank you for becoming a new member. We appreciate it. Jammin 126 threw 200 gems at us with the sunshine emoji. Thank you very much. Trisha Moran became a new member. Oh, family hug to you as well. Welcome. And thank you for doing that. Enchanted Pluto. I love that. What a great screen name. 500 gems with tulips. Thank you so much for your generosity. We appreciate that. And then one of our ride or dies, Melissa Filson, member 15 months. Sam Beningo, I think I'm pronouncing that right, is a great guest prospect. Yeah, I've watched some of Sam's stuff. I'd love to make that happen as well. So if anybody ever has contacts for guests that you think that would be helpful and enlightening, and you'd like to see us do our types of interviews over here, which we think are pretty good. You know, we try to get below the surface a little bit. We try to have some pretty in-depth conversations with people, and it's not strictly Q&A. Like when we were first started doing it, people were like, "Oh, let the guests talk." I'm like, "Well, it's not. I'm not a reporter just asking questions and wanting long, drawn out answers. I really am trying to engage in conversations that are interesting." So that's always been our approach, and it will always be our approach over here. But yeah, if anybody knows a way to contact people that you think would be great guests, let us know. Throw it in the community page or email us at a true crime pod. I always get those, and Tracy makes sure of that fact. So, and then Boston RN Kate. Oh, family hug. Welcome, welcome, welcome. Love to see all our Massachusetts folks out here. We appreciate you guys so very much. Got another new member, Christina Cameron. Thank you so much. Oh, family hug for you too. Thank you guys. Are they still doing the sidebar, Bay?
I mean, you're looking at it, right?
Yeah, it's like you got it playing, right? It's not paused.
It's not paused.
Okay. I am going to do it. It's at the time I wanted to get them out real quickly because of the timeliness with respect to that documentary. I think it was on Hulu that dropped. But yes, I'm going to. Like when I ended up putting together what I thought was a video and then I didn't watch before I went live on it, and it was doing all that just crazy shit. Like the video was freezing and you could hear the sound. So I just have not been able to prepare, because I have a lot of video from that case with my interactions with Lucy and us walking around out on the properties where she was claiming that all those victims were thrown in a well. And it's pretty fascinating stuff. And for the record, I mean, don't want to give you a spoiler alert. They haven't found anything, but I don't think that they're able to locate the right well, because all the wells have been filled in. And these aren't like Jack and Jill wells where you're seeing a large structure around the well and you've got the bucket that you're pulling. No, these were just holes in the ground that some of them were dry wells, some were wet wells that ultimately the landowner, Sean Smith, ended up filling in over the years because he has cattle and he didn't want his cows falling into the wells when they were walking through. All right, so you're seeing the sidebar still going on there. They're having a pretty intense conversation. The judge is holding court, like quite literally. At Dread, thank you very much. Another Uncle Alert, 440 gems. We appreciate that. I have no idea what the gems translates into in terms of money. Oh, is he still reporting that? Ugh, is that true? Ah, man, I hope that's going to suck.
What?
Nate's reporting the openings are Monday. Of course. Of course. You know, that's how it goes for us. Nothing goes right.
Well, that we
Nothing
can't.
goes-
We're on a plane, so
I mean, I'll be in chat. I'll be on the Wi-Fi in chat. We're going to be running it. We're going to be running it. Yeah, it's per reports on X. So, right. We'll know for certain when the judge utters the words. But Nate's usually pretty spot on. I found his coverage on everything, and he does a lot of the coverage out west, you know, with a lot of the Lori Vallow cases. Nate was always great on all those cases and everything that kind of happens out in the Mormon world out there in Utah and some in Idaho. He's been on top of all that stuff. So he's a great reporter. So yeah, I'm super, super bummed about that. I am super, super bummed. Let's see. Lori says your viewership might go up with this trial. Many of the YouTube trial channels are not watching this trial. I think they're going to be. Very respectful. So I don't know why they aren't going to watch. Yeah, I don't know. Like I'm glad that you found us. I truly am. And I think that you're going to find that you enjoy our channel quite a bit. I hope. That's the hope. You know, I mean, this is obviously a very intense trial to be covering. I kind of understand why some other law tubers don't want to cover it, but at the heart of it, I don't, because I think it's that important of a trial. I think it's a bad one to sit out, you know, and you know, the fact of the matter is I'll put our coverage up against anybody on any given trial, just typically. So it's like you know, I don't sweat other people having the trial on it. I do understand the concept that if there are a bunch of channels, the odds of people falling into us, you know, if we're not getting into people's algorithms, you know, that does make it easier. So, but you know, to me, the importance of what's being litigated here overrides that, you know, as selfishly as I'd want that to, you know, generate a large amount of new viewers for us. The bigger picture's more important to me, in terms of kind of getting this world out to the news and the information about mental health and its how it's been treated within the criminal justice system. Oh, no, I'm not. I'm like talking, so I wasn't looking at your text, Trace. Let me see. Tracy's yelling at me.
I got to get a charger.
Okay, so all right, yeah, Tracy was very busy. Okay, so the final juror has been picked. We know that. Okay, court is at lunch until 2, so we're past that. A jury has been seated, 18, a little unclear if the final juror was definitely seated as the clerk didn't actually announce it, but the judge formally ended selection after her questioning. So it sounds like we got our 18. Jury has been picked in Austin Drummond's attempt murder case from his time in prison. Okay, and then Nate had said a jury has been set in the Lindsay Clancy trial. Opening statements will now be on Monday. Judge about to hear motions, including one from Patrick Clancy about restricting. All right, so that's what Nate is reporting. So that's a bummer. That is a real bummer. All right, let's see. Got some more suit. Yeah, I mean, this is it seems like maybe they're litigating this whole thing at Sidebar. Okay. All right. Okay, so Legal Mama asked, did Patrick divorce Lindsay and remarry? I've heard that he did. I've heard that is an actuality. I have not been able to confirm that. I don't know what the situation with is with that. Monk's understudy today on my X was like, oh, you know, he had questions about, and I guess that this was a narrative going on out around when this case first hit about whether or not Patrick was in a relationship outside of his marriage. I don't know about any of that stuff. I mean, to go to the lengths to think that Patrick intentionally left Lindsay alone with the children in the hopes that something horrific would happen is so insane to me that I'm not willing to entertain it. It just sounds like an insane concept to me. So I don't, you know, like that is not a place that I'm willing to go. All right. So Nikki Lewis, member 4 months, openings Monday. Yes, we've seen. I'm still holding out hope that maybe the judge has a change of heart and he says, you know what? Got the jury impaneled. Let's get this thing started. Why waste a day? But it sounds like if it's been said, it sounds like maybe it's been said. So, or Nate was able to communicate with one of the lawyers on one of the sides, either the prosecutors or Reddington. So I could email Reddington and find out, but he's kind of busy right now. But thank you for that, Nikki. We appreciate it. And thank you for being a member for 4 months. At Dread, 199. I clicked to buy gems and it said 50 gems cost $1. All right. So there you go. So that helps. I appreciate that because I have no idea what they cost or what it means to us. Lacey Alvarez, 100 gems. Marshmallow. Hi. Thank you so much. We appreciate that. Genuine, who's been incredibly generous today. Thank you very much. Sent 20 at us. Looking forward to your analysis on this case and to watch with you in real time. Vape people. Hashtag vape people rock. Obviously referencing my wife and her proclivity for vaping. Thank you so much, Genuine. We appreciate it. Perry 3 with another $2. Thank you so much for that. We appreciate it. Yeah, I see you guys. I see you in chat. I see you in chat. Sounds like Mondays when it's going down. Man. See, it's our timing. It's always our timing for every major trial that I want to cover. There's always something that goes on. Like, we've had this trip planned for months. It's like literally. And of course, the opening statements for what I feel is the most important trial in the last 2 decades in terms of all the things that are going on with it is going to open while we're on a plane. I'll be in chat. We'll be live streaming it, but I'll have to be communicating via chat while I'm on the plane. I'll buy the Wi-Fi, and I'm sure Allie will too. But that just sucks. What a bummer. What a bummer. Let's see. Maria says, hello, Bob and Allie. I've never commented on here, but I'm a longtime follower. Well, thank you. Thank you for commenting. We have a very sweet community, so don't be shy about jumping into chat. I don't know how to get in touch, but I'd be willing to share my story about PPD and EPD. I'm in the UK. I'd love that. So the easiest way, Maria, is through a true crime pod at gmail.com. We'll throw it up, the link. We get those emails. We read those emails. It's a great way to communicate with us. Otherwise, you can always DM me on my Twitter account, which is defense_diary or _diary. I read my DMs as well. I'm less inclined to read Defense Diary podcast on Instagram. Like sometimes I'll go a week before I see those where people have DM'd me on there. So the email is probably the best bet. But I'm also going to post in the community page for people that would be interested, and we will be in communication with you guys, and we'll figure out what the best time to do that is. Probably on an off day, during the trial, because I'm sure there's bound to be some. There's no way the judge is going to go 6 to 8 weeks without having like a half day off or maybe a full day off. So we'll see. Plus, it's going into Labor Day weekend, so we'll see how that plays out with the court and what they're going to be doing. Obviously, Labor Day, whatever day that's going to be observed, that'll be an off day, obviously. So, but thank you for that. I really appreciate that. And I think it's so important. We truly will all gain something from hearing one another's stories. So if you're willing to share, we are all ears. We are all ears. All right, Liz Reed, illustrations. This case deserves care, love, and understanding. Our prayers to Lindsay and all the Clancy family. Thank you so much, Liz. We appreciate you. It's always great to see you in chat. Yeah, we feel the same way. We feel the same way. This trial has to be treated with kid gloves, and it has to be felt and heard and listened to, because hearing something and listening to something are two different things, and you have to keep your mind open to the concept, because the concept of what somebody might consider be giving somebody a pass on something as heinous as what's happened here is so incongruous that people might not be able to bring themselves to do it, and that's really what this trial is about. Because I think when the evidence is all out there, it's going to be pretty clear that Lindsay Clancy did not have control over her mind, and her mind had control over her. And ultimately, I think that that's what the evidence will show. Obviously, we have to wait to see it and hear it, but I'm inclined to think that that's what we're going to see and hear. And if that's the case, then, these jurors are going to be confronted with that dilemma that I was just speaking of. If you're of the mindset, I can't give her the pass. I can't utter not guilty, no matter what comes after it, So I'm hoping that people will change their minds as to that, because prison's not the answer in this. That's not justice for the kids. You know, I mean, I have long thoughts on who needs to be on trial here, and it's not Lindsay Clancy. It's just not, you know, and like, but the way that we handle that is with civil trials, and these doctors are all being sued by not just Lindsay, but by Patrick separately, separate lawsuits. So yeah, I don't know. Yeah. Lawyer 638, sorry to bring this up here. You don't ever have to apologize for Allison kicking ass in federal court. Won that trial where she said fucking bullshit. I want to say to that judge so many times, LOL, like even today. Yeah, I mean, that was a case. Allie went into the, you know, federal court, 7th Circuit here in Illinois, which I think their conviction rate is 99.2%. They win all their cases, and Allie went in on a trial, and she ended up winning that case. The jury came back with not guilty, and the way that it was reported, it was completely inaccurate. Allison had gotten a adverse ruling, and she was walking back muttering to herself. You're muted. Still muted.
All right.
I'll tell you later.
Counsel, I know we discussed some of the
You always
issues here.
say it wrong.
If you would want to
Me?
say anything else for the record in regards to your request.
If I might, very briefly, Your Honor. Again, as I indicated to the court on the record at Sidebar, and to Ms. Sprague and Ms. Buckingham and Mr. Reddington, thank you, first of all, Judge, for the opportunity to be heard. As everyone is aware, I'm not here as a lawyer representing the Commonwealth, neither am I here as a lawyer in any way representing the defendant. And on behalf of Patrick Clancy, the father of the 3 child victims in this case, he recognizes, and I recognize on his behalf, that he has no authority, no standing, and no intention of suggesting to this court or to the attorneys how to try their case, how to conduct direct or cross-examination, and perhaps most importantly, what evidence or exhibits should be introduced during the trial. Mr. Clancy, respectfully, Judge, is not seeking to close the courtroom at any time during the trial. Mr. Clancy is not seeking to address the admissibility of any evidence or to exclude any evidence from the jury. And he's not in any way seeking to prejudice the Commonwealth or the defendant in any way. What Mr. Clancy is seeking through counsel, Your Honor, respectfully, is to restrict in a very limited way the display and access to certain specific limited items of evidence and exhibits at trial to the jury, to the court, to counsel, to the court reporter, to the session clerk, and to the court officers. That is, the necessary parties who will be involved in trying the case. And I respectfully, Judge, I suggest that pursuant to the so-called Massachusetts Victims' Rights Bill and other statutes and cases with which the court is familiar, as a victim, as a family member of the 3 victims in this case, Mr. Clancy respectfully has an opportunity and a right to be heard through me or through his counsel. I suggest to the court that certain items of physical evidence or certain exhibits ought be restricted from dissemination and distribution, quite frankly, locally, nationally, and internationally, as is the case in this day and age. And for purposes of this hearing, respectfully, Judge, I would ask the court, and I would ask that the record reflect that the recording of the so-called 911 call allegedly made by Mr. Clancy be marked or be included as an exhibit for purposes of this particular request. I would also ask respectfully, Your Honor, that any photographs of the 3 victims in this case, whether taken prior to the alleged incident, whether so-called scene images, whether photographs or video recordings of the 3 victims, or any so-called autopsy-related photographs of the victims be marked for purposes of this hearing. Likewise, Your Honor, respectfully, I would ask on behalf of Mr. Clancy that the clothing being worn by the 3 victims during the course of the alleged incident also be reviewed by the court and marked as exhibits. And lastly, Your Honor, respectfully, given the background that I summarized for the court and counsel on the record at Sidebar, I would ask that the material that I have submitted to Your Honor from Patrick Clancy and correspondence that I've shared with both the prosecution and the defense and the court and have submitted to your clerk be also marked as an exhibit, and that it be subject to the motion to impound, which I have filed on behalf of Mr. Clancy, given the nature of that correspondence. In short, Your Honor, I am asking that based on the law, based on Your Honor's ability under the rules of impoundment, and specifically the rule as I understand it on behalf of Mr. Clancy and is cited by Your Honor in your initial order, which I believe is docket number 111, entitled Order Pursuant to Supreme Judicial Court Rule 119, that Your Honor does have the discretion to limit certain recording and certain transmitting of proceedings during the course of a trial. And specifically, as Your Honor knows, that rule, Supreme Judicial Court Rule 119, entitled Electronic Access by the News Media to Court Proceedings, states in one part that a judge may limit or temporarily suspend such access by the news media if it appears that such coverage will create a substantial likelihood of harm to any person or other serious harmful consequence. And the Supreme Judicial Court rule goes on to say a judge may impose other limitations necessary to protect the right of any party to a fair trial or the safety or the well-being of any party, witness, or jury. I suggest to the court that under those provisions, upon reviewing each of those 4 different categories of potential evidence and the correspondence from Mr. Clancy, that certain limiting rules should be adopted by the court and imposed on the media in this case. Lastly, Judge, I refer the court respectfully to 2 specific cases in the Commonwealth, which respectfully did not rise to the level of the extraordinary nature and facts in this case. One of which, Judge, was a case involving the alleged sexual assault of a young child, which was tried in Middlesex County several years ago. And after the conviction and after the case, a private documentary filmmaker sought access to the recordings of the witnesses who testified in court. And ultimately, the SJC found that the trial court's conclusion that the privacy interests and the emotional harm to the victim and her family outweighed the First Amendment right of the media or a documentary film member to get access to the actual recording live voices in the courtroom. And instead, the SJC, Justice Gantz, indicated that the proper mechanism, given the circumstances of that case, was to allow the documentary film member or the media access to the transcript, that is the written word. Likewise, in that case is Commonwealth versus Winfield, W-I-N-F-I-E-L-D. Similarly, Your Honor, I respectfully direct the court's attention on behalf of Mr. Clancy to a case tried in Essex County, Commonwealth versus Chisholm, C-H-I-S-M, in which then trial judge Lowy heard a motion to suppress when there was a videotape and a recording of a defendant's statement. And ultimately, the media sought access to the videotape statement to disseminate and distribute outside the courtroom. And the SJC ultimately upheld Justice Lowy's decision at the trial court level to allow the media access to a transcript of the videotape and a transcript of the defendant's statements, but not the actual videotape. Given that precedent, given Your Honor's discretion, given the spirit of the Supreme Judicial Court rule that applies to the electronic recordings of proceedings in your courtroom, I end as I began and ask the court on behalf of Mr. Clancy that certain limiting instructions to the media would be appropriate with respect to the 911 recording of Mr. Clancy's voice, certain photographs of the 3 child victims, and the clothing worn by the 3 child victims in this case. And again, on behalf of Mr. Clancy, I thank Your Honor for the opportunity to be heard.
All right, counsel, thank you. Attorney Sprague?
Thank you, Your Honor. With regard to the 911 call, Your Honor, I believe it's a public record available at a public records request, but I would defer to the court in terms of how you want to restrict publication of the 911 call during the trial or thereafter, as long as the Commonwealth is still allowed to show or play rather the recording for the jury, as the court has previously allowed that motion. Regarding photographs of the children, we had already addressed the autopsy photographs. The Commonwealth was going to request impoundment of those, and we would agree that they should not be broadcast or photographed in any way. Crime scene photographs, the children had already been removed from the home when the crime scene photographs and video were taken, so they will not appear in those photographs. The only blood in those photographs would be the purported blood of the defendant in the bedroom and on the exterior of the home, and then a small amount of blood from Cora in the basement. In terms of pre-incident photos, there has been mass publication of photos of the children already, but I would defer to the court on that as well. And regarding the clothing of the victims in this case, the clothing would be a shirt and pants that Dawson was wearing, pajamas and a bathrobe that Cora was wearing. There's a small amount of bodily fluid on the pajamas, and then pajamas that Callan was wearing. But although some of the material has been cut as they were cut away from the children, as EMS were working on them, trying to save them, there's nothing about the clothing that I think would suggest the need for restriction of publication of those items. So that's the Commonwealth's opinion.
All right, counsel, thank you. Attorney Reddington?
Let's call a spade, Judge. I have been in this court every time we've had pretrial hearing indicating to the court that the circumstances of the death is not in dispute. The circumstances of this horrific act are not in dispute. Repeatedly, the government has argued that they have a right to try their case, to present their evidence. Sure they do. But, you know, even though we're in a court, let's talk a little bit about humanity. Let's talk a little bit about how we should try this case. I have indicated repeatedly that we stipulate to every piece of evidence that they want. I have respectfully objected to you with the introduction of this stuff going into the trial. I understand your ruling, and quite frankly, it makes sense. You're trying a case. What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions of the jury, repeatedly placing in evidence items such as having Patrick Clancy, who's a young man who has suffered one of the worst tragedies that anyone could ever suffer. How that guy is still not an emotional basket case is beyond me, and he has been. But nevertheless, he is trying hard to move on with his life. He has, as the court is aware, they're divorced. He's remarried. He has a family. He has his extended family. Your Honor heard statements, and I know for a fact that it's true, that his family, totally innocent people that have nothing whatsoever to do with this case, are being harassed daily by news media, the New York Post, and all the rest of these types of salacious news media outside their door. This is his family. Some of them are in California. They have nothing to do with this case. But nevertheless, they are being hounded by the media. And the district attorney wants to put that guy on the witness stand and show little onesies with bodily fluid of his child. And they want to have him stand there. Oh, they're going to let him stand in the hallway while we listen to the 911 call.
Mr. Reddington, that's another issue. That's another motion. The question we have right now, respectfully, is Mr. Meyer's request as to how we should deal with this in regards to the media.
I agree with Mr. Meyer's request, as I told you with the sidebar. I think it's very appropriate. I think he argued it effectively. I think that Your Honor is well aware that you have the authority under the SJC rules to enter limiting orders, if you will, as to publication, as to what media can publish, what photographs they could look at and report. And I agree with what he had indicated to you in his argument.
All right. All right.
But I still want to say that I think it's reprehensible the way the government is trying this case.
Honor, if I may, I'd just like to say that I understand why defense counsel would want to brush past what happened to these children, whitewash away
All right,
what happened, and
what we're
focus
gonna
on something else.
Here's what we're going to do. We're going to end that now. All right?
So he gets an opportunity to say it.
No.
Oh my
Stop
God.
that. And if you want
Baby.
to address that in a different way, then we've got another motion in about 5 minutes that we're going to probably be talking about that. So let's talk about that then. This is I let counsel go and think it was going to wrap back up, and I didn't see that it was going to wrap back up in regards to the request. So that's why I stopped it. All right? This is not accomplishing anything in regards to the question of access to these 4 pieces of evidence. So I've got everybody's position. I've heard the arguments from counsel. What I'm going to do is I'm going to take it under advisement. And then what I'm going to do is issue an order probably tomorrow morning. And parties know I've listened to the tape, that 911 tape. I have looked at the autopsy photographs. I have looked at a crime scene video, which I imagine is where the crime scene pictures will come from. And so I'm familiar with the universe of the evidence that we're dealing with right now. I want to take tonight, go over the arguments from parties. That's why I'm stopped a little bit, everybody. I just want everybody focused on that issue. So I'm going to take this matter, the request of Mr. Clancy under advisement, and I will be issuing an order in regards to that request sometime tomorrow morning. All right? Now, there's one other motion that we have to address. And I believe that is the defendant's motion to limit witnesses. Is that correct? That's the motion we have. All right. Now, what I'm going to, I've read the motion. All right. I've read the grand jury minutes from all the individuals who have scheduled to testify. So I'm going to hear from the defendant just in regards to this, and then I'll hear from the Commonwealth. So, Mr. Reddington.
Thank you. And I will restrict the hyperbole, Your Honor. This motion is asking that Your Honor would direct the Commonwealth, since apparently the Commonwealth will not agree voluntarily to restrict the presentation of a large number of first responders to this tragic incident. First of all, let's face it, firefighters, EMTs, police officers, they're all wonderful people. They're doing the Lord's work. What these people have gone through or would go through and have gone through in their jobs cannot be underscored. And that's to be respected and embraced. But to present them one after the other in this trial to testify to, and I would very briefly, I don't even have to mention their names, but Duxbury Fire Department paramedic detailed to the home at 47 Summer Street, dealing with the defendant, Lindsay Clancy, treating with her outside with her injuries. The Duxbury Police Department sergeant went to the house, heard noises. Stephen Hall, there's a Duxbury Police Department officer, saw the defendant, heard screaming in the basement. Duxbury Police Department heard another individual, heard screaming in the basement, went in, saw the kids in the basement. Another firefighter heard noises, was outside. Another firefighter, Duxbury Fire Department EMT, saw Lindsay on the ground, was treating Lindsay, heard screams coming from the house, went into the house, describes the basement scene. Another Pembroke Fire Department individual, paramedic, same idea. Another Pembroke Fire Department paramedic was in the house. Duxbury firefighter EMT saw the other EMT carrying two kids out of the basement. Saw two children on the floor. Described the basement. Marshfield Fire Department paramedic went in the basement, saw the children laying on the floor in the basement on their backs facing upward. Saw blood, what appeared to be blood around the nose of one of the children. Another firefighter, Marshfield, assisted in the basement, heard the screaming, yelling, and made his observations. Another firefighter from Duxbury in the basement saw the children, little children, wearing onesies and feeties, laying on their backs on the basement floor, assisted as he could. Another Duxbury Fire Department individual, basement. Another Kingston Fire Department mutual aid gentleman, assisted in the basement, describes what he saw in the basement. Another Kingston Fire Department individual saw Pat, heard the screaming, and went downstairs, describes what he saw in the basement. Another Duxbury Fire Department individual responds to the scene, describes the scene, and then Duxbury Fire Department individual responds, saw Patrick in the kitchen, saw him sobbing, and made observations of the scene. So that was what was presented to the grand jury, and is what, from what we can see, is what the government would try to present at this trial. And I suggest to the court, without sounding as though I'm trying to minimize the horror of what transpired here and what these good employees of the municipalities had to endure and see, and probably to this day are suffering post-traumatic stress from it. Legally and objectively, I suggest to Your Honor that it serves no purpose other than to inflame or try to inflame the passions of the jury, one right after the other, offering them water, offering them time to gather themselves. And it may have worked in the grand jury, but it shouldn't work in a jury trial.
Counsel, is this motion, I understand the rationale behind it, but isn't this motion kind of a little premature? Because I mean, if you're talking about something being cumulative, don't I have to hear what the first witness says first, and then ask for the Commonwealth if there's an offer of proof, if there's anything different that this witness saw or did, or is going to bring to the jury? And I guess what I'm saying, it's difficult for me sitting here right now to tell the Commonwealth you can't call witness number 2 without knowing what witness number 1 is going to say. I appreciate this kind of flags the issue for me. It's helpful. I went back, I pulled out proposed Rule 403 that talks about, needlessly presenting cumulative evidence, so I could be aware of that. Got the cases pulled out for that. But I don't have everything in front of me. That's what that's the way I was looking at it right now. But Commonwealth.
Thank you, Your Honor. So in a typical murder case with one victim, we would be proving deliberate premeditation and or extreme atrocity or cruelty. Either one of those, proving first-degree murder, you'd have to prove that the defendant's actions caused the death. And the way we do that is with the person finding the body, then the people who treated the body trying to save that person, then the medical staff at the hospital treating them and then declaring them dead, and then the autopsy confirming that the actions of the defendant were the cause of the death. Here, unfortunately, we have 3 victims. So that multiplies those witnesses by 3. We also have the defendant herself who was treated at the scene. So then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them, that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5. Now, when the first responders arrived at the home that night, they thought they were responding to one victim, the defendant. Then they found out that the children were there, and they found them in the state that they were in, and it was a chaotic scene. They're asking for more help. They're trying to figure out what's going on. They're trying to treat these children, and so there's a lot of handing off. People start CPR. People move on to another child when someone else arrives who's better equipped to deal with, say, a baby versus a 5-year-old. And so we have multiple people working on these children trying to save their lives and then get them to the hospital and get them treated, and unfortunately, none of them survived. But the Commonwealth did not choose the number of victims, the defendant did. The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children in the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
You know what? I'll tell you, we don't need that.
Yeah, we don't.
All right?
Come on.
We don't need
Seriously.
that. The question right now for both of you is, this is a motion saying that there's going to be cumulative evidence. I don't know what's going to be presented. So how can I say that witness 2 doesn't bring anything extra after witness 1? I understand the theory. The Commonwealth, and I'm not telling the Commonwealth how to try their case. I'm not. And I guess the issue has been brought up that the defendant views the Commonwealth's approach one way. The Commonwealth views it a different way. I'm the one who's going to have to decide, and I don't have anywhere near enough information right now to determine if something violates, Section 403. But I understand the Commonwealth's position. There are a number of witnesses, and they all may very well bring something unique to the Commonwealth's case. So it's really what I'm probably going to be doing as we go through this is have everybody come over here to the sidebar, hopefully calmly, talking about an offer of proof. And is this witness bringing something? If they do, fine. I'm not restricting the Commonwealth thing. I appreciate the fact that it was brought to my attention. Now I can be aware of it. And we can just deal with it as the trial goes on. Just like, like we said, all of us have tried a number of homicides. So we know how it's done. And so I'm aware of how the Commonwealth has to prove multiple elements in every case. And so I'll be cognizant of that. So I guess probably just so you'd be prepared that the defense objection will be it's cumulative. And we come over here, and if there's some reason why there's something else that this witness brings or a reason why you want to call him, then we'll deal with it at that point.
The Commonwealth will be prepared.
All right. All right, so I'm going to take no action on this, assuming that it will be raised again in the next couple of weeks. We'll deal with it as it comes up. I appreciate the parties read. This is exactly why we have motions to eliminate. So I know that this is an issue that's coming up. I appreciate the Commonwealth setting out what their response is. So I'm kind of ready for that as well. So I'm not going to take any action on that motion and eliminate. Like I said, I'm sure we'll be talking about that a little bit later. Anything else we need to address today? Counsel?
No, Your Honor.
All right, defendant?
No.
All right, so the plan, we're going to be in recess on this matter until Monday. Parties should be prepared to give openings. I'll give a very brief pre-charge at that point, and then we will just begin with the evidence, hopefully Monday morning. And I will try to get that order out in regards to Mr. Clancy's request sometime tomorrow morning. All right. So again, I want to thank everybody for kind of helping me get through these issues today, and thank you for all your hard work on this. So we'll be in recess until Monday morning on this.
Board, all rise.
This matter is 2026 at 9 a.m. for the jury trial.
9 a.m.
Please play the courtroom, please. Thank you.
Of course. 9 a.m. We will be on a plane. So I'm not sure where Bob went. If he's told everybody where he went, and only I don't know where he is. Well, let me see what's going on. Hold on. Okay. I didn't realize he'd sent me a text. All right. So, I mean, the judge is taking it under advisement. I really liked his pushback to the state with all of their like messing around, you know, like trying to put on airs, like which one of these 3 children isn't worth the time. I mean, the argument that was being made by Reddington is what we've been screaming about, all of us. Like, none of this needs to be played to the jury. So why are you saying, state, which one of these kids, you know, doesn't matter, instead of asking, you know, why is exposing the jury to this horror of the 3 kids when there could be a stipulation, when mom's not disputing the acts and you're pushing this hard? I mean, we got, you know, like Steph said, thanks for your continued support. Stephanie says, wow, she's a piece of work, you know, talking about the state's attorney. I mean, the judge, I'm actually surprised he took under advisement the issue with the media. And I did just want to share, because I do have all the motions now. So this is what the oh wait, let me go this way. This is what the media responded to the motion, to the father's motion to keep that stuff out. So the media's response, I'll share this. Let's see. No, that's okay. So they respond to each of it. So for the autopsy and crime scene pictures, they're saying they don't want to publish it. They don't want to put it out there, but they want to be able to examine it. And I don't know, maybe that is actually a, you know, a fair request that if you're in the courtroom and you want to be able to review it, you should be able to. Well, I don't know. What are your guys' thoughts on that? On whether the people in the court should be able to look at everything but not publish it, not take pictures of it, things like that. See what you guys are saying. So Carol says she likes transparency. Yeah, I mean, I guess it's hard for me to sit here and say, well, no one needs to look at it here, but we need to look at it in Richard Allen, although it is different. And I did explain how it's different, but I think that, yeah, I don't see why they need to see the autopsy photos. That I would agree. I could see maybe why they'd need to see the crime scene photographs, some of the, but the autopsy, I don't see why anybody needs to see the autopsy at all. Right, and the Commonwealth explained what's in the photographs. Right. Mama of Medic says, I don't agree. We are not the jury. Well, that's the thing. For the autopsy and crime scene photos, they're not saying they want to publish it. They're just saying they want an opportunity to inspect it. So Rexy wants transparency. So I think I'm going to agree with you guys. I think the people in there, I don't know about the autopsy, why they need to see that, but that because who knows how the state's going to describe it. And again, I'll bring us back to Richard Allen. You have the state describing a crime scene as looking like one thing, and the defense describing the crime scene as looking remarkably different and having, very important aspects that need to be brought to the attention of the jury. So it is possible that they're going to try to describe the state in a way that either side could try to describe it in a way that makes looking at the crime scene relevant. So I'm going to agree with you guys on that. Not that it should be published to the public, but at least that people should be allowed to put eyes on it. And if there was like a portion of the crime scene itself that was important, obviously like the Richard Allen case, I'd be saying, yeah, no, we need to be able to look at it. And even if it doesn't get, published, people need to have eyes on this. So then the second part of it is, right, it's going to be testified to. They don't need the pics. I mean, in this scenario, it's kind of different. I hate trying to equate it to Richard Allen because it's just not the same. It's really in like no way, shape, or form a good analogy. So then on the pre-incident photographs and clothing, the Globe lacks sufficient information about the pre-incident photographs and clothing. They propose that members of the press and the public should be permitted to inspect those. And after they're offered or admitted into evidence, and should the court enter an impoundment order prohibiting photograph or copying the exhibits, the Globe or other members of the press and the public be permitted to move to vacate or modify the impoundment order based on the assessment of the contents of the exhibit and any public interest in the future. So that sounds fair enough on the I mean, I don't know why anyone needs to see the pre-incident photos. And if the clothings are pre-incident, they're not relevant at all to the case. But so then you've got the 911 call, and they talk about the rule that governs access to audio 911 calls. And the Globe submits that, as with the other exhibits at issues, members of the public and the press in attendance in trial be allowed to listen to the recordings when played in court. Well, obviously that's going to happen. I don't know how. I mean, were they actually suggesting that everybody wear headphones for the 911 call? I think the people in the courtroom were always going to be able to hear it. The Globe further submits that with respect to public dissemination of the 911 audio, the Commonwealth's position as to the relevance of the recording to this case mirrors the public interest in hearing the recordings. Because the Globe is not the organization authorized under Rule 119 to record or broadcast the trial. However, it defers to the Rule 119 designee to further address the issues of public dissemination of the recording during trial. So that's what they've asked for. I also have, oh wait, yeah, I did have it up. Okay, we also have, let me just see. Oh, so MBW says the 911 is out. We've heard it. Okay, well then I don't know. That's kind of a non-issue then at this point. So the other thing that was out, and I thought that the judge ruled on it, is this motion about the doctor. Okay, so it's, and I can just tell you guys about it. So it's the doctor that treated her lacerations to her wrist. Actually, let me just pull it up. So they said that Eaton Negro was working at the Brigham and Women's Hospital in January of 2023. On the 24th, Mr. Negro performed laceration repairs on the defendant's wrist injuries. The nature and extent of those injuries, as well as the witness's care and treatment of the defendant, are relevant and material to the case. Then they cite the rule. So here's what they said happened. They said the Commonwealth attempted to serve Mr., or it should be Dr., I take it, Negri, at his last known Massachusetts address in Malden, and learned that Dr. Negri recently relocated to New York. Okay, so that makes sense. On July 8th, 2026, the Commonwealth spoke to him on the phone, informed him of the impending trial date and the extent of his expected testimony. He relayed that he would need to accommodate his schedule, but would be willing to come to Massachusetts for testimony. On July 20th, 2026, Negri informed the Commonwealth that because he was not properly served in New York, he would not appear. So I guess he changed his mind, and initially he was willing to come voluntarily without like official proper notice. He probably is really messing with his schedule, is probably what's happening. And he's like, I don't want to schlep to New York. Like, what is all this about? And his lawyer's like, well, you weren't properly served, so you don't have to go. So the Commonwealth respectfully requests that the court compel him. Oh, well, we don't need all that. Sorry. Well, I mean, I've had it sitting there forever. On August 5th, 2026 and August 7th, 2027, and remain for one day. But it's 2 days. So between August 5th and August 7th, and remain for one day or until the conclusion of testimony. And then, so what happened after that was the state issues like an order for the judge basically to sign. And that's this. Let's see. I can't switch. Okay, so I'm going to pull it up this way. I thought it used to let me switch which screen I was sharing. Maybe it did, and I didn't realize it. I probably did. All right, so the certificate of the judge of the Commonwealth affirming that Eaton Negri is material and necessary witness. So they put this out, but it hasn't been executed yet. So and it basically just says the same things, you know, that he's necessary. He's a necessary witness. I'm assuming that all of this is really just his schedule, and that's what the issue is. But I'm sure the judge is going to issue the order. They've got time to get him served appropriately. So that's basically all they need. That's why they need to do this. They have to file this to get an out-of-state subpoena. And then they take this when the judge issues it, saying he's necessary, and they take it to New York, and then New York issues it, and then he gets served. So it's a process. It's a process. Let me see what you guys are saying here. I think Bob got all these because the color is dimmed. Sometimes hard to tell when they're all dimmed. Like what? I can't tell here. Are you dim or not dim? I'll start at the bottom. We've got a new member, Tennessee or TNLA or Tennessee Lake, GAL maybe, Gal. I don't know. Sorry, but welcome. Thank you for your support. At for Dread wants to know, why would any sick person want to see the autopsy stuff of kids like this? I don't know. I don't know. Look, we'll have to see if there's some kind of weird argument they're making that somehow, I don't know what any of it could be, actually. Yeah, I don't know. Side-Eye Jess, welcome. Family hug. Actually, that might be it for on I don't know if this one we put in. And then Bob highlighted this. I don't know if he answered it. Do we know if Reddington renewed his motion for experts? That's going to have to be at trial. If something happens at trial that prompts him to do that, and then I'm hoping Bob talked about Iceman's. Bob and Allie, I hope I don't get bashed. You never get bashed by us. But I'm really conflicted on this case personally, as I would expect most people to be. I'm keeping an open mind, but really struggling, as I expect most people to do. Also, what up, Doe? Yes, what up, Iceman? Thanks for your generosity. I mean, this is that kind of case. I don't think that anyone, all we can ask for is for people to be open-minded, to at least be open to hearing it, Fern's mom, thank you. Traveling and streaming epic multitasking. Yeah, well, it is disappointing about openings. So it would have really been nice if those started tomorrow instead. But oops. Because the doctor lives in New York and requires a subpoena, who pays? The Commonwealth. It's whoever's calling the witness. So if the defense was calling her, the defense would have to pay the travel costs. Yes, you have to pay for your witnesses to travel. So some states have like a set, you get this many dollars per mile. I've had to do it where I pay that mileage fee, but if they're flying, it would be, paying their flight. So he's also going to have to get paid to get there and to stay. So the Commonwealth will pay that. Commonwealth will pay that. All right, guys, I don't know. I'm hoping we got to all of your questions. Again, we all understand that this is a very, sensitive subject. And I think community love for each other helps. So let's all be nice to each other, love each other, and give each other the grace to have whatever feelings people want to have on this. Again, it doesn't mean that we don't, share our own opinions or give some pushback, but it's all done politely, respectfully, and respecting other people's, positions. And yeah, if you need to step away, you step away. And if it's not a case you can listen to, you can't listen to. And if you say, I don't care, I don't care, I don't even want to hear her mental health stuff, You want to live someone, you go to prison for the rest of your life. Fair, just not as someone on the jury. You know, then you're the one who knows I couldn't be a juror in this case, and I would openly tell them that I'm not up for it. You know, so I think that's it. I think we did good work. I think Bob. Shit. Is Tracy? Are you out there? How do we link this? So we're doing the Aaron Spencer defense live right after this. And there's some questions that came in on. Get back on screen. All right, we've got GAC Cat Mom sent $10 and said, in Georgia, most inpatient mental health facilities have been shut down, leaving so many people without any help and nowhere else to go. Sad situation. Yes, that's terrible. And thank you for your support. I'm just going to give a first name here. It's Tracy with an I. She also sent $10 and she said, the rug comment had me cracking up at my desk. And yeah, that was from an hour ago. So you guys can refer back to what we were talking about then. And then, so we have the interview with Aaron Spencer's defense attorneys. Hopefully you guys will all be there. You know, you never see a case get dismissed like this. So that is next. But I was trying to figure out if I could like link it how Bob does, like when he does it where you guys just get portaled over there. I think it's still okay. So I don't. Okay. So I don't know how to do it. I'm not going to do it. I'm just going to hope that you guys all. Oh, Bob has redirected everybody. Yay. All right. So you'll get your portal ride. Bob is redirected. Allie, text Bob. I did. Oh, Allie, text per Bob. Thanks, Iceman. And then Joylyn Simmons says, I'm sorry, but that prosecutor makes me sick. Agreed. What Lindsay did was horrific, but she was sick, begging for help, and every provider failed her. I hear you. And she's really playing to the public. And I hope the judge continues to kind of shut it down. But, you know, both sides are going to play to the public. It's just part of the deal. So we'll see you guys soon. If we I think it's set for 3:15. I think it's set for 3:15. I don't know. Yeah. Set for. Yeah, I don't know. I see upcoming. Oh yeah, live in 30 minutes. So 3:15. See you then. Love you. Thank you all. We appreciate all of you. And if we missed anybody in Venmo, since we're always asking for it, we'll get you at the end of the next live. See you soon. Thank you for your support. Bye.